decide appeals in the matters of the King on the application of E.ON and others and the Secretary of State and the King on the application of British Gas Trading Ltd and the Secretary of State.
One point of housekeeping, my Lord, if I may. You've asked the parties for a note on the meaning of judicial review in the TCA.
Yes.
We've had a draft from the other side, which we're still considering. Our position is going to be this, that we expect we'll be able to agree a list of other references in the treaty to judicial review. How far that will assist the court in and of itself, I'm not sure. If the court does wish to investigate what judicial review meant in the provisions that we are considering in this case, then that is going to have to be taken away to the Foreign Office and others.
Might have been thought about before now, mightn't it?
Oh, well, yes, it will have been thought about.
I mean, in the context of this case. Well, it doesn't matter. Sorry, that's very snooty on me. I didn't mean to be like that.
But because the...
You don't have a position yet on what it means.
Well, we will have a position, but in the time since yesterday, I don't have clear instructions.
I see.
So I propose to get them if the court wishes, or if that's going to be of significance to.
Well, the answer is I spoke to my lords. I don't speak for myself. I don't yet know, but there is a route by which it might be something we needed to deal with. Put it that way. I must say, I thought it was fairly clear. I hadn't realised there was a dispute about it. I just wanted to be given the, as it were, the supporting points. But if there is a real dispute about whether judicial review in that footnote, primarily and in the text, may mean the procedure as defined in section 31(1)(a, well, I can't say that it may not be an important point. So please do it.
Yes. So then I expect if the agreed note, if there is an agreed note, which will come to the court shortly after the hearing, will be on other references.
Well, there's no point trying to agree a note if you actually are going to be saying different things. I think we better then just have the appellant's note as soon as possible what they say it means. Your note in response if you don't agree with it.
Yes. Thank you.
But quickly. Thank you.
So the final point that I was going to make in my section on factual findings of the Divisional Court was to address a...
So sorry, Mr. Croppell. I've been saying you. Of course, the point to which it's more likely to go is the delay point with which you are not dealing. But of course, it's part of your case. It's just you're not addressing it on it. But Mr. Hickman, who is dealing with it, will no doubt have an input.
Yes.
Yeah. Okay. Thank you.
Yes. Yeah. So I addressed the court yesterday afternoon on the correct legal approach to the Divisional Court's factual findings, and the final point in that section was to address a submission made by the appellants in paragraph 11.2 of their supplementary skeleton argument, where they submit that because, at least on the Divisional Court's analysis, there is an application, or there is a need to apply the principle of proportionality as per Dalston Project and other cases. That's not a pure question of fact, they say, and about halfway down the paragraph they say that the court must determine the correctness of findings of primary fact, giving full weight to the advantages enjoyed by the virtues of oral evidence. And the implication, at least, is that the normal position as to respecting the actual findings of the lower court is displaced or is diluted because of the particular context of the proportionality test. And my point was simply to point out that that's not what Lord Justice Singh was saying. It's paragraph 36 in tab 68 of bundle 5. And on page 2557.
Are you asked us to go to it?
I can read it.
If it's just very short, just read it.
Lord, Lord Justice Singh says, secondly, findings of fact by the lower court must ordinarily be respected, especially if it has heard oral evidence on factual matters that were in dispute. And there's nothing about deciding upon the correctness of the factual findings. It's an orthodox approach. So that's that. My next.
How is that consistent with what Lord Newberger said in Re B?
So the position, the subject matter of the quote from Re B, which is set out in paragraph 35, is the situation where the appeal court has decided that the first instance application of the proportionality test was wrong, and then the question is, does the appeal court go on to decide for itself, or does it send it back?
Thank you. That's the answer.
And actually, just to make a point now, conveniently, that I was going to make later, my submission would be that if you were to decide, firstly, that the Divisional Court was correct to apply a proportionality test, but secondly, that it had erred in the application of that test because of so let's say they'd applied too wide a margin of discretion or given too much weight, then our submission would be that this court is not in a position to make its own finding on proportionality. You have only, in the supplementary bundle, got before you a tiny fraction of the evidence which was considered by the Divisional Court. If somehow they have got it wrong and they need to apply a different legal test, or they needed to have applied a different legal test, then our submission would be that the matter must be remitted to them for application.
This is, yes, not so much to apply the different legal test. The hypothesis you're putting to us is if we find that it was right to apply a test of proportionality but didn't apply it properly.
Yeah.
Yes. So if
sorry.
Yes. Okay. Fine.
That's what I mean. Then our submission is the consequence should be that the case should go back to the Divisional Court to re-examine the proportionality test on the correct basis in the light of the full factual picture that they had and will have again. So you simply aren't in as good a position, or indeed a sufficiently good position based on the small selection of documents that you have. So then my next section is to address ground 3, and in particular the first part of ground 3, which essentially focuses on the factual findings of the Divisional Court, and I need to go into a little bit more detail about what those findings were. Well, there was an application from our side to admit a chronology, and it is a chronology which sets out.
It's an application to us.
Yes.
We haven't dealt with. Which
Which you haven't dealt with. I thought that I would raised it as a convenient moment.
Yes.
There is a chronology in the bundles before you, which is the Appellant chronology, and which cherry picks quotations from documents that we felt were misleading and didn't agree to. What we have done is to produce a chronology which is strictly tied to the Divisional Court's factual findings, and which gives you a paragraph reference to each of the different stages along the way.
When did you make this application?
We made it in writing.
You were too polite to say this hasn't been answered.
6th of January.
Came in during the vacation is my excuse, but very well. I'm sorry that wasn't dealt with. But do you need to? If it's just an advocacy tool, you don't need permission to put it in, do you?
Well, we apply for permission. I don't propose to...
Anyway, have you got it?
Yes.
You asked us to look at it?
Yes. Well, I am asking you to admit it and to bear in mind that you have that tool available to you for understanding the sequence of events. I'm going to, in my oral submissions, give you some highlights, which will...
But if it will assist your presentation of your oral argument to have, as it were, a chronology which you're basing it on, I can't see that's objectionable. It's obviously not agreed.
Well, it's
I
not
used
agreed.
to say when I
It's
was
not...
at bar that it was a breach of professional to agree a chronology because each party wants to present the chronology differently. But even if that's not as over cynical, I quite understand that different parties want differently shaped chronologies.
Well, well, Lord, some work was done on this.
Well, are we taking too long about this? Do you want to give it to us?
Yes, I do want to give it to you. I'm not going to go through it in my presentation this morning, but we did apply for it to be admitted, and we maintain that application.
Let's see it. We will appreciate that it is obviously the other side have seen it for ages because
Yes.
they read the email even if we didn't.
My Lord, we've seen it. We did oppose its introduction because we thought you didn't need the benefit of yet another chronology.
Well,
but I've heard what
that's
my
for
Lord
us to
said.
decide, yes.
Well, I've heard what my Lord said.
Thank you very much indeed. We don't promise to read it all, and we do not. We accept that we understand, of course, that it's not agreed, but it may be useful. So thank you.
Thank you. So the...
Are there any other matters which we didn't deal with?
I can't think of any, my Lord.
No, good, thank you.
So the highlights of the factual findings of the Divisional Court, and I've grouped these under a number of headings. Firstly, I think there are 11 in total. Firstly, E.ON withdrew from the sales process for reasons which were independent of availability of government support. And that's paragraph 39 of the Divisional Court's judgment. And shortly after they had withdrawn or communicated their withdrawal, they were informed by Lazard that government support was anticipated to mitigate volatility and hedging risk. So, paragraph 39.
Yeah.
Second point, on British Gas. British Gas was invited in early April 2022 to identify what government support it was asking for. It would ask for. Paragraph 45. It was clear to British Gas that there was scope for discussion as to government support for hedging, which was the only form of support which British Gas had raised, and that is 46.3. So this is in April. On the 10th of June 2022, British Gas was specifically informed by Lazard, and that's Mr. O'Shea, was specifically informed by Lazard that there was scope for government support for balance sheet restructuring and hedging transition. And that's 72 Roman 9. These are the texts between Lazard and Mr. O'Shea, which only emerged after Mr. O'Shea's first witness statement. When Ms. Kotsaver, on behalf of Lazard, referred to balance sheet restructuring and hedging transition. And then paragraph 77, Roman 1, the Divisional Court is satisfied that a passage in Lazard's Phase 2 bid review was a fair characterisation of the position, that being that British Gas had been aware of government openness to possible support to enable a transaction and encouraged to put forward their requirements in order to commence a discussion on possible structures. Post-withdrawal have noted and objected to press coverage regarding possible government cash support, etc. So it's simply not correct, as my learned friend Mr. Beale submitted yesterday, page 28, line 17 of the transcript. It's simply not correct that there had been no indication to British Gas that government funding would be available. Now, the question, and I digress from the factual findings for a moment, the question of what British Gas says that it and the other bidders should have been told is, of course, important to their case and was explored in argument with my learned friend yesterday. Before the Divisional Court, British Gas's position was that it and other participants needed to have been told that government support was available, but they were expected to ask for it. Now, can I hand up an extract from the transcript before the Divisional Court, just to make that point good, because it is important to understand what case the Divisional Court was addressing. So this is, I think I may have said that this was Mr. Beale's submissions, which is not correct. It's Mr. Harris, who was then representing British Gas, making submissions. And on from page 75 at line 24 down to 76 at line 20. I ask my lords.
So which page did you say?
75.
Yes.
Line 24 down to 76, line 20.
Would you like us just to read that?
Yes, please.
Yes, thank you.
So no suggestion or disavowal that the level or amount and the structure of any government support would have to have been made clear. That was, according to British Gas then, a matter for negotiation. Now, the position has been developed by my learned friend Mr. Beale to argue that British Gas and others should have been told that support, government support, was available for two particular matters, for balance sheet support of bulb and for hedging. My learned friend accepted in exchanges with my Lord Justice Underhill yesterday that what my Lord described as a mere indication of potential support, placing the onus on the bidders, would have been sufficient. You put that to Mr. Beale at page 29 of the transcript from yesterday, and that was agreed. Even if...
so what's the reference page?
Page 29 of the transcript.
Yep.
From yesterday.
Line number.
Yes, sorry, just 1 second. Line number 19. Sorry, no, line number 10.
Thank you.
Now, we don't accept, and it appears that the point isn't being pursued now. We don't accept that there was any flaw in the process, simply because the onus was placed on bidders to come forward with their proposals for government support, as opposed to...
I'm very sorry to rise. I just wonder if my learned friend's given the court the right line reference.
Oh, I see.
I can read out...
I didn't follow it up at the time. Hang on. I've got day 2 here.
What he's aiming for is...
Wait, give us a moment. Page 29.
Yes. I think his target is probably 11 through to 90. He may have given himself the reference to pulling out because I misspoke and said I didn't think I'd said British Gas were pulling out, and I did misspeak on that, for which I apologise both to my learned friend and the court. British Gas didn't pull out. But I think the point my learned friend's aiming for is essentially my recognition of yes at 19, but that's in relation to some very specific proposals that puts me by your lordship.
Well, no, we can see what was said.
Yes, that's the right. That's what I meant. So we don't accept any flaw in the process by the onus being placed on bidders to come forward with their proposals for support, and nor did the Divisional Court. But none of that matters, because both of the appellants, in particular British Gas, was told specifically that government support for both of the matters which Mr. Beale referred to was on the table. And really what British Gas's complaint amounts to is that they should have been sent a letter telling them what they already knew.
Is it right to say that the government support was available, as opposed to was available if needed in a particular bid scenario? Because if you had a bidder that was prepared to deal with the hedging problem itself, it had a sufficient balance sheet to do that, then it wouldn't have been right to grant a subsidy to deal with that, because it wouldn't have satisfied condition C.
Well, absolutely. Available if needed.
Yeah.
But it was widely acknowledged and known in the market that certainly at a certain point that it was very likely to be needed, and that's part of Mr. Beale's case. My third area then is in relation to Tulip.
So I'm not confused with your structure. What was your first area?
Was E.ON withdrew,
Oh, I see.
and E.ON. Secondly was British Gas. Thirdly, Tulip. Tulip had been informed on the 28th of June 2022 that the government was open to an arrangement to resolve working capital and hedge collateral issues. That's paragraph 70, Roman 8.
70.
70, Roman 8.
Thank you, sir.
But Tulip withdrew from the process, informing Lazard that there was not a package of government support that could change their position. That would change their position. 70 Roman 8.
Can I just check my note? These are all the paragraph numbers that you gave us at the start, which then my lord said we didn't want at the start.
I was starting to go through these,
that's
but yes.
Great, thank you.
And I'm going on to mention some paragraphs that I didn't mention yesterday. So for Scottish Power, they were...
So before you move off Tulip, the point put against you is what appears in 74, because one doesn't have to look at the parties that we know about, but one looks at the market generally. It appears that Tulip didn't appreciate that there was appetite in the government to provide support, which might be said to give an indication that, well, if they didn't realise that, maybe others didn't, who didn't come forward at all, and therefore there wasn't an opportunity to re-engage with them.
Well, there weren't any findings made about what Tulip did or didn't know, save for what appeared on the face of their correspondence. But had it been an issue before the Divisional Court, we would have said everybody knew what the position was. These are all. There was a submission by my learner friend yesterday that these were mice trying to get something past the cat. You know, these are very substantial companies with direct lines of communication into government, very experienced players, and it was widely known that some kind of government support was very likely to be necessary. Tulip, if it had thought that government support wasn't going to be available, was corrected very quickly and told that it was, if needed. Sorry, so that's paragraph 70, yes, 70 Roman 7 and then 70 Roman 8 are the two paragraphs on that. Fourthly then, Scottish Power, and sorry, my lord, I should say that one point of contrast between the kind of formal procurement process...
So sorry, did you say that if Tulip didn't know the position, they were shortly disabused, and you referred to 70...
Roman 7.
I was looking at 72, that's why. Thank you. Yes, I see. Yes, thank you.
The sort of formal procurement process which I learned from Mr. Peretz was advocating as the gold standard for the CMO principle. That involves a series of formalised stages. You put in your bid or not, and if you don't put in a bid by a certain date, you can't put in one in the future. It's all very formalised. This was not that kind of process. There were, as you've seen, there were attempts to get bidders interested who hadn't been interested, people who were interested and then pulled back. It was a much more iterative process than a formal procurement. Scottish Power, so my fourth heading, Scottish Power was informed on the 19th of April 2022 that Lazard was open to proposals which contemplated a government support package, paragraph 65 Roman 1. but Scottish Power withdrew from the process on grounds of volatility and risk, even if there were to be what they described as a government-backed adjustment mechanism, 65 Roman 3. Fifth heading, Octopus. Octopus was not given materially different information about the availability of government support than that which was provided to British Gas, E.ON and Scottish Power. Paragraphs 61 Roman 4 61 Roman 6, 63.
Hang on 1 second. I've got 4. Where in 61.6 does it make that point?
The last 6 lines.
Yes, I see. And where next?
63. And 64. It's the first 4 lines of 64. Octopus had simply reacted differently to the potential availability of government support, of which the other potential bidders were equally aware. And that's 64 Roman 4. And it's the last 4 lines, 64 Roman 4. And 120 Roman 3. And in that paragraph, it's the 5th line.
Sorry, which again?
120 Roman 3.
Thank you.
We are not persuaded that there was any significant difference between the content of the teasers of HMG support given to potential bidders, only in the reactions of the recipients to those teasers. My learned friend submitted yesterday, and this is critical to his case. He said that nobody else had been given the assurances that Octopus had. Page 51, line 8 to 10. That's squarely at odds with the findings of the Divisional Court.
Can I just ask, when they refer to the teasers in 123, are those the references that you've just given us, where, rather than a formal teaser?
Yeah. Yes. It's not a formal letter, such as Mr. Beale says should have been sent, but assurances, indications, tell us what you want.
Thank you.
And as part of what Octopus was and wasn't told, I think I addressed yesterday the Quantock email that you were shown by the Appellants on a couple of occasions from Octopus's advisor, Mr. Quantock. And I referred you to paragraph 61, Roman 10 letter E, which is page 112 of the bundle in the Divisional Court's judgment. And that's the point that Octopus were not assured that government support would be delivered. They were assured that the timetable indicated by Lazard would be delivered. Sixth head. None of British Gas, E.ON or Scottish Power would have made a bid to buy Bulb's business, even if the unfairness that they had alleged had not been present. And that's paragraph 120, Roman 3. What the claimants have proved conspicuously unable to say is that the statements which were sufficient to lead Octopus to re-engage would have led them to engage and remain in the process to the point of actually bidding. And similarly, 120 Roman 4, if they had received same approach as Tulip had done on the 28th of June 2022, that also would not have led them to re-engage to the point of making a bid. And the reason for that is that all of British Gas, E.ON, Scottish Power were only interested in a split book transaction, taking on some of Bulb's customers, which the Secretary of State had been advised against. Paragraph 73 is the British Gas position on split book only. And 120 Roman 5 is Scottish Power and E.ON on split book, and also referring to British Gas's strong preference for that approach. So the submission my learned friend made yesterday, page 49, line 10 to 13, that British Gas pulled out because they didn't have the assurance that government funding would be made available. Whether they pulled out or not, because they didn't have the assurance that government funding would be made available, that again is directly contrary to the actual findings of the Divisional Court. They weren't interested in the transaction that was on the table. Seventh head, the M&A process was conducted by the administrators, but followed closely by the department, which had provided regular input, including on the fairness of the process. And that's 251 Roman 4.
Sorry, paragraph number?
251 Roman 4.
Thank you.
And I make that point because the appellants submitted on a number of occasions that there was a schism, as they put it, between those with control over the process. I think they put it, the JEAs and those with overall responsibility, as they put it, I think the department. That's not a fair characterisation on the factual findings of the Divisional Court. Point 8 is that following input from the department, the JEAs used rational criteria in order to decide which potential bidders to approach who had not submitted a Phase 1 bid. And that's paragraph 59 is the criteria for reapproaching. My learned friends rely on the not entirely clear words in the opening part of 59, but then, as was pointed out to them, there are subsequent findings then as to what the criteria were. And 55 to 58 set out the lead up to that reapproaching in terms of the department's involvement and influence. Point 9, the administrator's recommendation of the octopus bid was based in part on the outcome of the M&A process, but also on counterfactual analysis and benchmarking analysis. That's 251 Roman 5. And there was also a further analysis conducted by Ernst & Young, which supported the JEA's recommendation, 251 Roman 6. And my final point, so I've only got 10, my final point is that the M&A process could be relied upon so as to treat the octopus bid as a fair reflection of the value which the market placed on Bulb's business in the prevailing circumstances. Paragraph 252, can I ask you to look at that, please? The first sentence in 252 is a finding that the Secretary of State was reasonably entitled to conclude that the M&A process had produced a fair reflection of market value. But then the second sentence, the in any event, we are not persuaded that the process conducted by the JEAs in conjunction with Lazard was not one which could be relied upon so as to treat the only bid which had emerged from the process as a fair reflection of the value which the market placed on Bulb's business in the prevailing circumstances. Now that, in any event, and there is a double negative that perhaps one can strip out, but the in any event is a hard-edged finding by the Divisional Court that the M&A process was reliable to produce market value. So even if we're wrong about the standard of review and it's not rationality or it's not a discretion or anything like that, in any event, we don't accept that this process was unreliable in producing market value. And a similar point is made at 253 Roman 3, where they reject British Gas's contention that there was unfairness i.e. undermining of the reliability of the M&A process, because information provided to one bidder was not automatically shared with other bidders. And that again would be a feature of a regulated procurement process, but wasn't a feature of this process.
To your point, these are also hard-edged findings.
Yes, yes, that's of the same type as the second sentence of 252.
Can I just ask you to, at this point, then just deal with Mr. Beale's point? Because what he says is, well, it might be a rather strange M&A process, but actually, when you're looking at this question, which is fair for the purposes of avoiding unfair subsidies, it's a different question from a strange M&A process, where transparency is exactly what you're after.
Yes. Well, we submit that one simply can't regard this process as equivalent to a subsidy auction for a wind farm contract, say, where all the bidders are asked to do is to bid a price, a price per kilowatt hour or whatever it is. This was a highly complex transaction which could have been structured in any number of ways, and the way to get best value in the judgment of the JEAs and endorsed by the department was not to be specific, not to be prescriptive about structure, and not to be definitive about the availability of government support. Now, those were found by the Divisional Court to be reasonable judgments to make in the circumstances, but it's simply not a standard transaction of the type that my learned friend described. And that being the case, so this was a bespoke process. One still then asks the question at the end of the process, was it good enough to give confidence that market value had been achieved? So there aren't any rigid rules, as Mr. Perez would have it, about how you have to do this. But you ask the question at the end of it, on the CMO principle, would a rational commercial market operator have regarded this as market value? Similarly, under the subsidy control.
Sorry, I just don't. You lowered your voice. Would a rational market operate? What was the phrase?
Would a rational commercial market operator have regarded this the output of the process as market value?
Yeah, but then you said something about subsidy.
And then similarly, a similar question falls to be asked in the case of the admitted subsidy to Hiveco, which is whether it was the minimum necessary or whether it was a...
But how do you formulate the test there? Would you say a similar... Would a rational CMO have regarded this as the minimum level of...
No. So
what's the right test for the level of the subsidy?
Well, the right test is the test set out in the subsidy control principles. Is the subsidy proportionate and limited to what is necessary to achieve the objective?
Okay, hang on one second.
And we say, as you know, that those are not hard-edged questions. There is judgment and evaluation. And one looks at the material then on the basis of which the Secretary of State decided that that principle was satisfied. And the material was an M&A process producing the octopus bid, supported by counterfactual analysis, benchmarking analysis, Ernst & Young, advice from the JEAs.
Yeah, I'm just trying to articulate to myself, it's probably pretty obvious, but how the subsidy test and the CMO test, as it were, fit together in a situation like this. Is it something along the lines of, in deciding whether the subsidy is proportionate and limited to what is necessary to achieve the relevant objective, the relevant objective is to give such level of subsidy as would ensure that a market buyer would come forward. I'm just trying, I mean, you have been putting it all in terms of, as it were, a market-based analysis, but formally what the subsidy regime requires is a focus on minimising the level of any subsidy. The two obviously fit together, or have to fit together in a situation like this, but I'm just wondering how you articulate the fit.
So,
putting it well.
Lord, in this particular case, and it may be different in different cases, but in this particular case, the question which one asks at the CMO stage, is it a subsidy at all? That question is a very similar, if not the same question, under the second principle, because having a competitive process which produces a bid at the end of it is a way, supported by benchmarking, counterfactuals, etc., is a way of discovering what the minimum subsidy is necessary in the circumstances to achieve the objective of saving Bulb and Bulb's customers. Lord, I don't want to reinvent any wheels here, but the subsidy control assessment does set this out in some detail as to how we said we believed at the time the subsidy was proportionate and limited to what was necessary, which was in, this is page, just for your note, 628 of the supplementary bundle, which was based in part and in significant part on the process, on the sales process which had been undertaken, but also on other factors, including counterfactuals, etc. And it runs over 4 pages as to why we said that test was met. But as I say, in this particular case, there is a very high degree of overlap between the question, was there a subsidy at all to Octopus, and was the subsidy to Hiveco proportionate? So put it this way, my lord, the M&A process produced the best terms which were available from the market at the time, and that bid from Octopus did involve some subsidy to Hiveco, but it was a lesser subsidy and cheaper for the public purse than all of the other alternative options which were being analysed at the same time. And it's just so you understand, this wasn't a case of either a subsidy is paid or a subsidy isn't paid. This was a case of either Bulb is sold to the only bidder, or subsidy, a different kind of subsidy, would continue to have to be paid to Bulb until a buyer could be found or an alternative solution. And Lord, you don't have the detailed counterfactual benchmarking analysis which the Divisional Court considered, but those are the sorts of considerations which were then brought in when considering proportionality.
Why don't we have that? What form is that in? What are you referring to?
Well, so the Lazard Phase 2 bid review and the JEA's produced a report and Ernst & Young produced a report.
I see.
That, I mean, well, if you'd like to see it, I'd be very happy to.
Well, no, we only want to see what parties think we need to see. But I just wanted to be clear what you were referring to.
Yes. And that's what's being referred to in the subsidy control assessment in the pages that I referred to.
Putting it very simply, the government was effectively funding the hedging of bulb in administration. So that one of the alternatives, one of the alternative solutions was to continue trading and run a sales process the next year. But that would have involved the same or similar level of hedging costs for the next 6 months as this deal did.
Well, I think in fact the government wasn't paying for hedging, but it was paying spot prices,
Well, it was paying
which would have been worse.
It was compensating bulb for the fact that it couldn't
yes,
hedge. Yes,
absolutely.
Yeah.
Yes. So, in short, we commend the Divisional Court's detailed treatment of the facts of this case, but that detailed treatment should not obscure that ultimately this was, at heart, a straightforward case. British Gas, E.ON and others, highly sophisticated commercial operators, they knew very well that some kind of government support would be necessary and that it was open to them to make proposals for that support. They didn't do so, even when they were told in terms that government support was potentially available, because they weren't interested in buying Bulb's business, but only in acquiring some of its customers. There was no confusion, there was no shooting in the dark, they simply weren't interested, and nor ultimately was anybody else, apart from Octopus. That in a nutshell is what happened, and that is what the Divisional Court found at some length.
What do you say about the allegation that the government failed to follow, and JEAs, failed to fail Lazard's advice? This is paragraph 54 of the judgment. Given in relation to what should be said to bidders or potential bidders in phase 2.
Yes. So the Divisional Court specifically rejected the allegation that that the government had failed to follow Lazard's advice.
At the outset, I think.
And I'll ask Mr. Halliday to pull up the reference. Yes, I think it's paragraph 253, Roman 2.
So that isn't the approaching 1, is what happens at the outset, third line of 1.
Yes.
This complaint is having accepting that that's okay. When you get to the re-engagement and trying to get parties into phase 2, Lazard were saying, it is said, you should have gone back and said HMG support is now available. Or...
Oh, I see. Well, there were some very detailed findings about, firstly, about how re-engagement would be with the bidders who hadn't bid in phase 1, how re-engagement would be conducted, and there was in particular scripts agreed as to what the JEAs would say about government support. And then you find that in practice, and in the paragraphs that I have referred to, that Lazards did give further indications of government support being available if needed, where they felt that was necessary to keep a bidder interested in the process, such as with Tulip. So we don't accept that there was any specific advice which wasn't followed, and in any event, Lazard did do what the claimants say should have been done, and they did it for British Gas. They had done it for E.ON. They did it for Scottish Power. They did it for Tulip. Well, if there are any other paragraphs, I'll mention it before I sit down. Can I then move on to the final part of ground 3, which is my learned friend Mr. Peretz's submissions on Article 364.3 of the TCA, and then 367.3. Can I ask you to turn up the TCA provision 364.3? Bundle 8, tab 93, page 3682. Subsidies that are granted on a temporary basis to respond to a national global economic emergency shall be targeted, proportionate and effective to remedy that emergency. The Divisional Court at 276 of their judgment held, first of all, Roman 1, that the Russian invasion of Ukraine did constitute a national or economic, a national or global economic emergency, and that subsidies provided were targeted, proportionate and effective response. And
the court, all they're simply doing there is saying what the analysis, the SCA established.
Yes, sorry. So then it's the first sentence of Roman 2.
It's so sorry. Okay, I didn't even mind.
We are satisfied this is an assessment reasonably open to the Secretary of State, and we do say, of course, that what constitutes a national or global economic emergency does have an element of judgment in it. See the MMC case, that's the standard public law approach. What the appeal is concerned with, and it's grounds of appeal 3.3 at page 40 of the core bundle, the appeal is only concerned with the question of whether the subsidy was a response to the emergency. And what's argued is there wasn't a sufficient causal link between the emergency and Bulb's difficulties.
Sorry, where are you reading from?
It's paragraph C at the bottom of page 40. Sorry. Paragraph C at the bottom of page 40.
Yes, sorry, yes. Yeah.
Now, on one level, whether the payment of the subsidy was a response to the emergency is simply a question of fact, which one can get from the subsidy control assessment. But what the argument is from the claimants is that this wasn't a response because Bulb was already in difficulties. To which the answer, as was put to my learned friend Mr. Perrott, in argument that as one finds in the subsidy control assessment, just for your notice, page 638 of the supplementary bundle, that the emergency caused by the invasion of Ukraine had transformed the extent of any support that would be required to complete the transaction and to save Bulb's customers. So there was a direct causal link between why subsidy was being paid and the emergency which had been identified. And as was also put to my learned friend by my Lord Justice Dingemans, one also sees from the subsidy control assessment that the predicament of Bulb's customers was an emergency to which the subsidy responded. My learned friend has further submissions as to how a subsidy cannot fall within Article 364.3 if it's only given to one undertaking. And he submitted, as he did before the Divisional Court, that what the drafters of the TCA had in mind was the sort of COVID-type subsidy arrangements which are made available to a whole sector, or indeed the whole country. To which the Divisional Court said, well, Mr. Perrott, have you got anything admissible under the Vienna Convention on the Law of Treaties to enable us to reach that conclusion as to what was in the minds of the draftsman? Answer, no. And what the article actually says, as I've just read it to you, is that subsidies should be targeted. So the idea that you can't even come within the provision unless you indiscriminately grant it across the sector just can't be right. So nothing in that point. And then the final part of the argument is on 367, 3 and 4. Now, my lords will understand, I hope, that if there's no good challenge to the findings on 364, 3, then we don't get into 367, because 364 disapplies 367. If we're wrong about 364, so we do have to look at 367, then that's page 3686 of the authorities bundle. And the ground of appeal in relation to this. So it's the Divisional Court at paragraph 277. And the complaint of the appellants is that Octopus didn't contribute significant funds or assets to the cost of restructuring, to use the words of the provision. And they refer to the statutory guidance that wasn't then in force. There is reasoning in the subsidy control assessment, page 639, as to why significant funds or assets had been contributed by Octopus. And we submit that the Divisional Court's reasoning in 278, which highlighted the amount of money that Octopus had put into the transaction, that it was the only bid, and that Octopus had deployed other resources, not simply cash, to make the deal go through. Those are all perfectly sound findings in our submission. But ultimately, if you're being asked to second guess what was a significant contribution within Article 367(3), well, we're squarely in the Monopoly Emergers Commission type case. You'll recall substantial was the word that was being discussed in that case. We're talking about significant, which is then further explained in the guidance that wasn't in force as either 50% or more, or a substantial contribution below 50% in certain circumstances. But we're squarely within the territory of evaluation and judgment, and there's simply no basis to undermine the Secretary of State's judgment or the Divisional Court's finding. Well, those are my submissions, unless I can assist further.
Thank you very much.
Lord, it's maybe a convenient time to have.
Yes, I don't know the shorthand right. I would appreciate it. In that case, let's have it now. 5 minutes.
That's Mr. Hickman. Yeah. Mr. Hickman's having.
And the whole. Okay, well, we need to.
It's pretty damaging.
We just need to.
You asked the question yesterday.
At the beginning, yeah.
They were honest. We didn't do
Yes, you mean if you conducted an unfair process, or does it matter?
What makes no difference to you? You're not here as supposed to be advocates. Yes, under the TCA is actually a division.
Party.
Yeah, you've got to be the interested party means anyone other than the two main parties. There's an insertion agreement. That's what it's talking about. It says they have to have under domestic law.
In any other public law case, if you came along with an unfairness argument, so it didn't affect me.
No, but I'd just like to bring a judicial review.
No. David, so
Have you got enough space?
No, I'm all right. Yeah, I'm used to it. I'm not going to get anything out of
glad you're doing this.
Court rise if able.
Yes, far away, Mr. Gibbon.
My Lord, I'm first of all going to address you on the Senior Courts Act, Section 31, and the relevant authorities. Then the reasons why the Divisional Court was entitled to exercise its discretion to refuse permission. And then why the TCA does not affect that conclusion.
Yes.
First of all, can I ask you to turn to the Senior Courts Act? It's in Volume 8, Tab 87, 3635, or at least the page I want to take you to first.
Just one moment.
35. Section 31 deals with applications for judicial review. And as was mentioned previously, Section 31(1) requires claims that seek one of the former prerogative writs to be brought by judicial review. It's a mandatory requirement. There are then essentially a series of protective provisions that follow, one of which is over the page at subsection 6, which provides a discretion to the High Court to refuse either leave or permission, as it's now called, or any relief if it considers that the granting of relief sought would be likely to cause substantial hardship or substantial prejudice to the rights of any person, or would be detrimental to good administration. So there is in effect a ring of protection around applications for quashing orders and mandatory orders, which include this very ample discretion. It's important to notice that the trigger of undue delay relates specifically to the granting of relief. So if it considers that the granting of the relief would be likely to cause substantial hardship or substantial prejudice to the person, then it may either refuse leave or refuse the relief sought. If undue delay is present, that triggers the discretion, and the discretion, we say, is a very ample one.
Sorry, this is very basic stuff. The mandatory obligation in subsection 1, we're all familiar with that class of cases where it is necessary for a court to decide that a decision is unlawful in order to decide some other question, but which arises in proceedings in the ordinary courts. And in those circumstances, it's for the court to decide whether the case is an abuse and ought to be brought by way of judicial review. But if it decides that the only way in which it can say it isn't an abuse will be if a quashing order is not being sought as such. Is that right? I put it rather complicatedly.
Yes, my lord. I mean, we've moved quite a long way from O'Reilly and Mackman.
I know.
Let me give you an example. If you're seeking a restitutionary remedy based on an ultra vires decision,
yes,
say an ultra vires demand or an ultra vires payment, a restitutionary action doesn't have to be brought under this procedure.
Exactly so. But it seems from the way that the statutes are drafted, I never had to think about this, that only works on the basis that in those restitutionary proceedings you are only seeking the restitution. You are not as such seeking to quash the unlawful act.
Well, you are not seeking to quash the unlawful act.
Yes, right.
Rather than as such. Yes.
Why? Well, what's wrong with as such?
Well, because in a sense you may be seeking relief, restitution relief, which may involve would involve, in the hypothesis we're discussing, a finding that something has been done unlawfully by a public authority.
Well, that's the very point I'm making. That's why I said as such. But you're not seeking to have it quashed. You're only seeking, as part of your claim for your primary relief, for your relief, to have it found to be unlawful.
Yes, and a monetary remedy.
Yes, right.
That's right.
Sorry, that's pretty obvious stuff, but I just wanted to pin that down.
My Lord, it's important also to recognise, as the Privy Council did in the Maharaj case, that with the advent of the civil procedure rules, there's considerable flexibility in how the courts deal with those provisions. And paragraph 41 of Maharaj, which is in the authorities bundle at 1552, tab 37, the Privy Council said that the civil procedure rules have developed in a way which allow issues raised by claims which are said to be brought with undue delay to be dealt with inter partes or at a rolled up hearing if necessary. And that's what was done here. And it's important to a point I will make at the end that the court here has dealt with the merits and permission on a rolled up basis rather than dealing with permission.
If you're going to deal with it at the end, I won't ask you questions about that now, but that seems to be slightly intellectually impure. It has dealt with relief, but it has dealt with the merits, but it would be, why would the position be different if it hadn't?
Well, my Lord, I'll answer that when I get to it. But that is the position, and it's common now for permission issues to be dealt with on a rolled-up basis, whatever they are. And that's, as I say, paragraph 41 of the Maharaj case. Can I also take you, though, to the ex parte Furneaux case, which is a judgment of this court at tab 5 of the authorities bundles, page 75. And this was a slightly convoluted set of...
So, sorry, which bundle did you say?
It's the authorities bundle, my Lord, at tab, volume 1, tab 5, page 75.
Yeah.
And it was a challenge to a decision not to approve pharmaceutical services at a doctor's surgery. The facts don't particularly matter. We can take the holding from, first of all, the head note, page 76, and the head note effectively sets out two propositions established by this court. First of all, if an application for judicial review failed to apply promptly, or an applicant for judicial review failed to apply promptly, he was guilty of undue delay, even if the court was satisfied in the light of all the circumstances that there was good reason for the failure to apply promptly. In such circumstances, the court has discretion under 31(6) to refuse, on the grounds of undue delay, permission to make the application for relief sought if it considers the grant of relief would substantially, and I emphasise grant of relief, would substantially prejudice the rights of another person. So the first point is that there can be undue delay even if you've got a good reason, and the good reason is something to be considered in the exercise of discretion, rather than affecting whether there's delay in the first place.
Sorry, I just the exercise of discretion rather than
whether there is undue delay. So whether there is undue delay that affects that.
I thought question of good reason fed into whether it was undue, but
my Lord, this is what this court has said. It goes to the exercise of discretion, and secondly, there's no requirement in section 31(6) of the Act that there be a causal connection between prejudice and undue delay for the refusal of relief. Instead, what was required was a causal connection between prejudice and the grant of relief before the court can exercise the discretion. So if we pick those points up in the judgment, my Lord, you can see that second of those propositions is set up at page 79, little h. The judge below had decided that there was no causal connection established between the delay and the substantial prejudice which might have occurred. and the court over the page, this is Lord Justice Mann, whose judgment had the agreement of the other members of the court, rejects that and finds that's an incorrect approach to adopt. Can I just ask you to read page 80 from the citation of the Stratford-upon-Avon case down to the end of D.
End of
D.
End of.
Sorry, I'm sorry. And can you go to F, please?
Down to F. Yes.
And also the sidelined comments on the next page, page 81, please.
Yeah.
So, if in fact it is said, well, there was undue delay, but it didn't, nothing really turned on it. What the court says is that may be appropriate to be taken into account in the exercise of discretion. So, my lord, those are the core principles that regulate the approach to section 31, subsection 6. We say that the question whether there is undue delay is a highly context-specific question of fact, and if there is undue delay, what follows is the court's exercise of a pure discretion. Both those matters, by their very nature, are matters which this court can only interfere with on very restrictive grounds. Effectively, if there was no evidence for the conclusions are rationally unsupportable, or if there's some erroneous self-direction by the court as to the law. We say the appellants are not close to establishing any of those things in this case. My lord, before coming on to the facts, I want to show the court just a couple more authorities. The first is the Argyll case, again at tab 1, page 8. This is an authority referred to by the court. In fact, the court extensively refers to authorities in its judgments at paragraphs 136, 137 by reference to the Administrative Court Guide and the authorities it footnotes, 147 and 150. And amongst the authorities it refers to this authority, indeed it refers to it twice. This is a well-known case that concerned an attempted takeover of distillers, and it was competitive in the sense that there were two entities competing to take over the company, Guinness and Argyll. And as you see from the head note at page 8, second sentence, in February 1986, the Secretary of State referred Guinness's bid to the Monopolies and Mergers Commission for an inquiry. What then happened was the Secretary of State gave his consent to that reference being withdrawn or set aside, laid aside as it's described in the head note at F, and that was the subject of a judicial review challenge. Now, the challenge was brought exceptionally quickly. It was brought the day after that decision was made. And the need for expedition of that nature was emphasised by the court, which nonetheless went on to refuse to grant relief in the case in its discretion by reference to the passage of time that had passed before its consideration. And can I ask you to read page 19, D, through to the end of the judgment of Sir John Donaldson, Master of the Rolls, please. Now, my lords, we say the essential message from that passage is the importance of finality and certainty to third parties in the first place. And you see just below H on page 19, the court refers to the legitimate interests of Argyll, but says that their interests in putting Guinness in bulk, as it describes the claim, as being of little, if any, weight. It's public administration, decisiveness, finality that are preeminent considerations. And over the page, at page 20, the fact that even a few days to get to the permission stage in a case where many people have relied on a transaction would be a very long time in this context. Similar, albeit more abbreviated comments are made by Lord Justice Dillon.
Just so as to understand, so the decision was made on the 20th of February, is that right?
Yes, the claim was issued on the 21st. You get this from page 10,
yes,
at H. So the claim was issued the next day.
Hang on 1 second.
It's the very bottom of page 10, you get the chronology.
Yes, but what's the date of the actual decision?
20th of February.
Where do we? I've been very slow.
It's
Where do we
page
see?
7. Unfortunately, that's the one date that's not there. That date you get from page 774E. That's if you slot the 20th of February into the
So I see. Okay. So yes, I see. Then leave is given the next day. Well, leave is given on the 21st by Mr. Justice Webster.
Yes. 6th of March.
Yeah, in fact, it's the 19th. You can see if you look at page 9 in the just below the head note, appeal from McPherson, J. Quash the laying aside by the monopolies merger on the 19th of February of a merger reference. I see. Yes. Okay. Then all the rest of the dates are there.
Just, we'd ask you to
That's
read-
fine. I just wanted to get a feel for just what sort of timescale.
Exactly, my lord, exactly. And that's the way that the Divisional Court also had regard to this case. I don't want to ask you to read them right now, but for your note, the other sideline, there's two other sideline passages in the judgments of Lord Justice Dillon on pages 23 to 24, and in the judgment of Lord Justice Neal at page 27 over to 28.
This case isn't about delay, undue delay at all, is it?
My lord, it is.
It said that the delay of 1 day was undue delay, and therefore some discretion came in for that reason.
No, what it is they refused the action in their discretion, having regard to a number of factors, one of which was the time that had elapsed. Now, it's not a case of refusal of permission on grounds of delay. I quite accept that. But as I've shown you, the provisions of the Act are the same. You have a discretion to refuse permission or a remedy. And so that's the first authority I want to show you. Next is Dolan, which is another judgment of this court. And that's in the authorities bundle at 1960.
Which authorities bundle?
For tab 52, Lord Burnett, Chief Justice, and Lord Justice King, so Lady Justice King.
Sorry, you say tab 60?
Tab 52.
52, sorry.
And page
1960.
60.
1960.
Thank you.
And this was a challenge to the first lockdown regulations during the COVID pandemic. Lord Justice Singh was a member of the court, and paragraph 35.
It is in fact a judgment of the court, isn't it? Yeah.
The court expresses concerns in that case that the claim had not been brought sufficiently promptly. It was a case that called for very quick action indeed, given the fast-moving situation. Many third parties were potentially affected. I'm reading paragraph 35 in the centre of the paragraph.
What was the delay in that case, or the elapsed
I think
time?
I think it was
Almost 2 months.
yes, I was going to say it was well into the period. My lord, another example that we've used, and it really is only an example, this one, is the prorogation case of Miller, which is in the Divisional Court judgment, is in the bundle, the authorities bundle 4, tab 45, page 1745. That was a case started on the basis of a report in the press that the Prime Minister had advised on the prorogation of Parliament, and as recorded in the judgment in the first paragraph, proceedings were started the same day, and self-evidently, I'm sure this court will recall, the proceedings moved very quickly because Parliament was prorogued shortly thereafter, and indeed it went all the way up to the Supreme Court within a few weeks. The appellants rely on the case of Young and Oxford City Council. We don't need to turn it up, it's at tab 13 of the authorities bundle. This was a case which does not cite any authority, which does not purport to establish any principle, and it is expressly decided on the particular circumstances that arose in that case. In that case, it was found reasonable for the claimant to have sought further information because it was impossible for them to bring their claim without that information. And the Divisional Court considered the authority which was put to them below, and they said it turned on its own facts, and that's paragraph 150 of the court's judgment. There is a subsequent authority of this court, subsequent to Young, which is in tab 17, the Finn Kelsey against Milton Keynes Borough Council case, which we'll very briefly look at, tab 17, bundle 1 of the authorities bundle. This was another planning case, it's 446.
Thank you.
And there are essentially two propositions that you can take from this case. The first is that where you are aware of an impending decision, you're expected to act with greater speed. And secondly, that it's not a justification for not issuing your claim, or taking time to issue your claim, that you've engaged in pre-action correspondence. And in this case, there was a decision of the council on the 17th of December. There was then an effort to rescind that decision, and that decision was taken on the 8th of January. You get that from paragraph 18. Pre-action protocol letters were sent. That's paragraph 19. Lord Justice Keane, at paragraph 22, sets out the principles. Perhaps I could just ask you to read paragraph 22, the first 3 sentences. Then in paragraph 25, what satisfies the requirements of promptness will vary from case to case. And then at the end of paragraph 25, in the present case, the appellant and those associated were aware of the committee's decision in December. And that's the point that I've made, that if you're aware of an pending decision, although it's not taken for some other time, that's a relevant factor. You, as it were, you don't have a standing start where you discover a decision that you're not previously aware of. And then at paragraph 27 is the point about pre-action protocol not removing the obligation to bring claims promptly and engaging in pre-action correspondence not being an excuse. And that's a proposition that was cited by the Divisional Court below. The Court also notices, at paragraph 28, at the end of paragraph 28, that the particular context there, which was a challenge to a renewable energy project, was one that contributed to the need to act speedily. Just two more documents and authorities that I want to show you. First of all, the Administrative Court Guide. This is in the Authorities Bundle 8, tab 103, at page 4024, at 6.2.5. Just makes the point.
So sorry, which
4024, it's at tab 103.
or 103,
And again,
as sometimes say.
it's referred to by the court below, and it makes the point that you should try and satisfy the pre-action protocol by sending pre-action letters, but that it may not always be possible. And indeed, in the present case, the pre-action letters were sent, but they gave 24 hours for response. So they required a response within 24 hours, which was provided. Normally, you have 14 days for response. And finally, the Ejiofor case, a judgment of Mr. Justice Bourne, which is in the tab 64 of the authorities bundle at page 2430. This was a challenge.
Sorry, I'm being slow. Which bundle?
Bundle 5, tab 64.
Tab 64.
I believe so.
Yes, thank you.
2430. The judgment of the Administrative Court is a challenge to a report of the Ombudsman. You pick that up, paragraph 2. The report named the claimants in a way that they said was unlawful. And there's a section dealing with delay from paragraph 26 at page 2434. A quashing order would obviously cause administrative confusion. The existing report can't be removed. There would presumably have to be a corrected version, 2 competing versions. That in turn emphasises delay is a very important consideration in this case. This is not a case that affects the rights of any third parties. And then, of significance, paragraphs 28 in the last sentence through to the end of paragraph 30, the court also takes into account the fact that there have been no application for interim relief. My Lord, turning then to the reasons why the Divisional Court was entitled to exercise its discretion to refuse permission, can I first of all just show you, or remind you, the grounds of appeal, which are in Core Bundle 1, tab 3, from page 37. And they're essentially in 1C of the grounds of appeal. I'm not going to go through these one by one, but I just wanted to make the general point that we make in our skeleton, that the way the grounds of appeal are framed do not properly engage with the threshold test that has to be met in any challenge to findings of fact and exercise of discretion in this court. They are essentially failures, it is said, to have sufficient regard to various factual matters. In most cases, it's not a failure to have regard to something, it's apparently a failure to have sufficient regard, which means, in my submission, little more than a failure to accept the appellant's submissions over those of the defendant. In terms of the facts themselves, I want to begin with the consequences of relief being granted, which is the central issue, as we've seen under section 31(6). The first point is that the extent to which the 2 decisions that were challenged affected the rights of third parties was, on any view, exceptional. When the Energy Transfer Scheme took effect on the 20th of December, the rights and obligations and assets of the various parties to the transaction itself changed, together with hundreds of supply contracts and 1.5 million customers of bulb began to be migrated onto Octopus's IT platform. And you get that description for your note, I don't want to go there, from Ms. Walker's 5th statement, which is in the bundle, in the supplementary bundle 1, tab 12, at paragraphs 19 through to 20. That's at pages 349.
What page, sorry?
Pages 349 to 350. paragraphs 19 and 20. Indeed, the energy transfer scheme regime, which involves effectively a statutory novation of many, many rights and obligations, was used precisely because of the extreme complexities involved in transferring a business. Secondly, this was a case in which the remedies that were sought were designed to reverse and unwind the transaction. Each of the claimants sought not only recovery and damages, financial remedies, but they sought quashing orders in respect of the funding and approval decisions. And I'll show you in due course also an order of prohibition prohibiting further monies being advanced to Hiveco.
It's maybe something you want to come back to, but this, even at the time perhaps that the proceedings were issued, certainly by the time of the hearing before the Divisional Court, it will have been apparent that there were, as it were, two possible purposes for the hearing. One, to have the orders quashed, and second, to get some form of financial remedy for damages recovery or whatever it might be. Given that Section 31 gives you two options, to refuse permission or to refuse particular relief, why wouldn't it be more appropriate, for the very reasons you have given, simply to say, well, it's too late to quash the orders because of the enormous consequences, and we will therefore refuse that form of relief, but we won't refuse permission for the JR at all, because it's the appropriate vehicle for the, or at any rate, an appropriate vehicle for the recovery proceedings, or the financial remedy proceedings.
Well, I'll come on and deal with that.
You're going to deal with that later, are you?
I think it's better if I come on and deal with that when we take the chronology a little way forward. But essentially, the court has to consider permission first. Okay, the court has. It's obliged to consider permission.
Yes, but it can grant permission. It could grant permission, saying, "But I want to make it quite clear that this doesn't tie our hands when we get to relief."
It could. I mean, one of the concerns about that would have been in itself given rise to huge uncertainty, because then there would have been, okay, well, what is going to happen? Is the court going to pull this? Effectively, the court's saying we are not going to. We are not.
Well, there's uncertainty if you make a rolled-up hearing as well. In theory, the world didn't know whether a quashing order might be made any time up until the decision of the court.
But it would have prolonged the uncertainty a good deal.
Why?
Well, if the court had said, let's say the court had upheld the claims and said, but we'll consider remedy in due course, there would have been a huge uncertainty. There might have been an appeal to this court on the merits.
No, but what I'm suggesting is at the time that the court made the decision that it did, having initially directed a rolled-up hearing, it would have said, instead of saying we refuse permission altogether on grounds of delay, it had said we refuse permission and we refuse any quashing order, but we will go on and hear, well, either now, because everyone was ready to deal with it, or on a later occasion, if the court thought that was more appropriate, the question of a financial remedy.
Yes.
There will be no uncertainty there of the relevant kind.
My lord, that, if I may respectfully say so, is a different proposition. The proposition that my lord has put to me is that essentially you refuse permission to claim any of the quashing type remedies, but you allow permission on the basis of financial remedies.
I think if I didn't make it sufficiently clear, that's what I had in mind.
Yes. Well, that was so. The basic answer to that is that it was for the claimants to restrict their claim in that way, and they did not do so.
Why was it for the claimant? Why can't they hope for the best and try and get that?
Well, my lord,
why have they got to opt?
The Divisional Court had to determine permission on the basis of the claim that was pleaded and the claim that was put forward. And I'll take you through this, and I'll show you the way it was put. And in my submission, the Divisional Court,
fine. If you're going to deal with this in more detail later, let's park it for the moment.
When you deal with it later, you deal with the proposition that the court's quite used to people putting in 5 grounds and only granting permission on 1, rather than saying, you put in 4 silly grounds and I'm going to refuse you everything.
Yes, my lord, I can. I think it will help if we've seen the facts. But can I just return to the point I was making, which is that these remedies were designed to reverse and unwind the transaction. There is no doubt that if the remedies sought had been granted, there was serious detriment to good administration and the rights of third parties. That is made apparent by what the appellants themselves submitted to my Lord Justice Zacaroli in the Chancery Division proceedings, when they sought to persuade the court not to set a time for the ETS to take effect. In those proceedings on both the 11th and the 24th of November, the appellants could not have been clearer as to the prejudice and detriment to good administration that would be caused if their judicial review succeeded. These submissions were not made as an adjunct, passing comment. It was the very thrust of the application to the Divisional Court that it should not set the effective time. And can I just take you to the transcript of the 29th of November here at Supplementary Bundle tab 2.
You can, Mr. Hickman, but you may be, I'm not expressing obviously any final view, but you may be hammering away at a point which isn't really what this is any longer about. It's not difficult to see why it would have been very difficult to make a quashing order. So it's just a question of your timing.
Yes,
I wouldn't spend a lot of time on this aspect, but if you want to, do.
Well, my lord, I do want to just flag a few points in this particular, but I can take some other points more quickly. If you turn to tab 23, at page 519. And if we pick it up, page 178, submission that's being made by British Gas here, line 21, is that there's a realistic prospect that the statutory precondition will fall away. That's the statutory precondition being the consent of the Secretary of State. So it's saying there's a realistic prospect that the judicial review will succeed. And your Lordship should refuse to set time until that realistic prospect has either materialised or been rejected by the administrative court. And then page 180 at 16, the counterfactuals that you've been presented with are, if you don't decide in a way which allows the scheme to be effective before the end of December, or 22nd of December, if you don't decide that, then the deal is going to fall over. So the position that was being put was, well, this has got to go ahead or the deal is going to fall over. On the other side of the debate, if you do decide, and it turns out, A, that the judicial review cannot be resolved within that time for whatever reason, which may include the fact that the Secretary of State chooses not to provide disclosure in a timely way, we've seen plenty of evidence of that, or for whatever reason, and then subsequently, after your Lordship has given an effective time, and the transaction comes into effect, the Administrative Court decides, actually, the Secretary of State's approval was unlawful. Now, it's not talking about quashing order here, it's just decision was unlawful. What are the consequences? And they also, we would submit, bad. In fact, we would say they are very bad. And then paragraph at line 20, likely to have chaotic consequences for the market, for consumers, and is the sort of submission which is worth pausing to reflect on a moment. It's also likely to have catastrophic consequences for Octopus. And my lord, it's not unimportant that these submissions were made, and they are, in my submission, alarming submissions, and they're submissions which are referred to by the Divisional Court and clearly influenced the Divisional Court's assessment of permission. Now, my lord, there was a directions hearing on the 20th. The effective time, as we know, was set by my lord. That passed. There was then a directions hearing on the 27th of January before Lord Justice Singh and Mr. Justice Foxton, at which applications were made by the claimants to amend their pleadings. And you have the amended pleadings in the bundle. It is significant that the appellants at that point did not take the opportunity to amend their pleadings to retract the relief sought or clarify that the effect of the remedies that they were seeking was not going to have the consequences that they had foreshadowed in their submissions to the Chancery Division, but they did not do so. Before the Divisional Court, the position of the claimants on remedy was set out in the skeleton argument of Scottish Power. This is confirmed by Mr. Patel's note, paragraph 4. Again, that skeleton argument does not abandon any of the remedies, nor the claim to unwind the transaction. What it suggests is merely that there could be a pause or a short suspension of relief to allow the parties to negotiate and see if there's some agreed way of taking things forward. And if that could not be agreed, then it makes clear that there should be a return to the court for the court to grant the remedies claimed. My lord, that for your note, I think we need to take it up, is in the core bundle, tab 23.
Have we not got the reference to Ms. Patel's note?
It should be there.
Yeah.
My lord, it was only in seeking permission to appeal and after an explicit request from Lady Justice Whipple that the appellants changed their position. And we see that in core bundle tab 29, page 783.
Sorry, can you give me that reference again?
Yes, it's core bundle tab 29. It actually begins at 773.
Oh, thank you.
And if you look at paragraph 1 of that note, at 774, you get the background that by order dated 11th of October, Lady Justice Whipple adjourned the appellant's application for permission to appeal. The order indicated the court wished to have submissions focusing on the issue of delay and the issue of remedies. And what was said in this note, if you go forward to 784, paragraph 31, the appellants say, although initially sought by them, the appellants recognise that it would no longer be practical to seek to unwind the ETS. And this is over a year after, and reallocate transferred customers away from Octopus. The siren warnings of chaos from the Secretary of State and the JEAs are therefore ill-founded. Pausing there, the siren warnings of chaos were coming from the appellants rather than from us. But this pragmatic recognition makes the full repayment of the subsidy all the more important. Now, this was the first time that the claimants has indicated that the relief that they were seeking would be limited to financial remedies that would not have a consequence
what Mr. Beale says is that it was the court itself at the Divisional Court hearing which discouraged, or indeed presumably prohibited, submissions on remedy. He then says, which I appreciate you can't know because it's within his bosom, but that his position would have been, well, the pleaded remedies are quashing, followed by, but as an alternative, recovery. If the court had made it clear it wasn't interested in quashing, for all the reasons you're identifying, he would certainly have pressed an argument for recovery, as he would have been entitled to do.
My Lord, first of all, the court made it very clear that although it wasn't going to hear submissions on remedies, it was hearing any submissions that needed to be made in relation to the issue of undue delay. I can give you that transcript reference if you need it. So it was very clear that it was not prohibiting any submissions that were relevant to whether permission should be granted. And
so are you saying that it was not part of the claimant's submission below on the question of delay that, well, if delay is a good reason for not granting any relief on quashing, we still want to pursue our other remedies?
That's right.
Can we see that in the skeleton argument or in any transcript of the hearing? It strikes me as slightly surprising or inconsistent with what we were, and inconsistent with what I understood from Mr. Beale.
Well, we can look at the skeleton argument of Octopus, which was adopted by the other parties, which was there.
Do you mean Octopus?
Sorry, of Scottish Power. So perhaps we skipped over it, but perhaps we should have gone to it. It's at page 664.
In the
Core bundle tab 23.
Core.
Core bundle, sorry. Must be core bundle 2. I'm sorry.
Just give us a moment. You can draw attention to any particular passages, but it's quite a short passage. Let's just quickly look at it. This is not actually under the heading relief, but you say this is material.
It's under the heading relief, 664, tab 23, core bundle, relief and conclusion.
Yeah, well, let's just quickly look at it all. Yes, so this appears to proceed on the basis, ignore the claim for damage, that this seems to proceed on the basis that they are in fact wanting damages and recovery, but they also want a quashing order, as it were, en route. You see that at 64.
Yes, madam.
And then but that doesn't mean that a quashing order would be necessary.
Well, my lord, can I just emphasise a couple of points on these passages? First of all, the very first sentence of paragraph 63, it reaffirms the relief that's pleaded. Okay, and if you look back to
what's the references to paragraph? That's
paragraph 5 of Scottish Powers, the skeleton.
Well, we better just do that, hadn't we, then?
You can.
All right.
It's at Core Bundle 1, page 373. tab 14. Sorry, it's 375, tab 14. So this is paragraph 5 of Scottish Powers skeleton argument. Quashing orders. Then an order directing the Secretary of State to recover the unlawful subsidy. And an order, this is what I mentioned before, restraining the Secretary of State from giving any further subsidy to Hiveco. So this is a wrecking claim. They want to pull the transaction apart. And that's what they've said.
My Lord, I'm sorry to raise, it's getting a little tendentious. Was the court taken to paragraph 66, page 665, the core bundle, tab 20?
Well, I don't want to take Mr. Hickman too much out. You've got to write
I know. I'm afraid I was just confused as to which passages you were invited to read.
My Lord, the next one I want to highlight is paragraph 64, where they're now introducing a consequential direction for the setting aside of the effective date, second paragraph.
Sorry, it says, where 60?
Paragraph 64.
Yes.
And then what's proposed at 66 is what I mentioned earlier.
Yes.
Abbreviated form.
But we don't need to look at the whole panoply of relief being sought. The important point is that it certainly included recovery and indeed damages.
Yes, my Lord, that's right. Can I just emphasise it, the last sentence of 66? Because what my learned friend wants to line is, well, we weren't totally unreasonable, or we were going to give a period for everyone to get together and try and find a way forward. But in default of that, the matters should go back to the court, which would be invited to lift the suspension of the quashing orders and direct recovery of specified means and remit the matter to the insolvency court. So it's very clear what's being sought.
You're simply making the point that they were not abandoning their claim for a quashing order. We've got that. But
no
the point. But what I'm interested in is whether they said anything that is inconsistent with a fallback position that if you not prepared to grant a quashing order, we will nevertheless want, but you're not prepared to grant a quashing order because of the consequences of doing so, we'll nevertheless want a recovery order. And Mr. Beale says, and on the face of it, it seems perfectly plausible that was his fallback position if the court had been interested in relief.
My Lord, in my submission, in light of the history that you've seen, where the appellants are putting forward those alarming submissions before the Chancery Division, where they've had opportunities to amend their case after the effective time has passed, where they've put in a joint skeleton argument which has somewhat reformulated the way they put their remedies. They had many opportunities in which to say to the court, permission is resisted on grounds of undue delay. If you're not prepared to grant us permission for the quashing orders, then please just grant us permission for the financial remedies. They could have said that. They had ample opportunities to put their case in that way. Okay? They didn't.
Well, he says, I didn't have ample opportunities, we were never allowed to address the court on relief. You say, they didn't need, that's not part of the claim on relief, it's part of the answer to the claim on delay.
It's absolutely, my Lord.
Yes, I see. And where do they deal with delay in the skeleton argument? Well, in fact, I found it. It's paras 41 to 46. You'll say we'll find nothing to that effect there.
I believe so, my Lord.
Okay.
It's not with respect for the court to design the claim, particularly in this context, for the claimants. The claim was as put. They were seeking a range of remedies. They said very clearly what the consequences were going to be if they were granted, and permission was refused on that basis. And in my submission, was well within the discretion of the Divisional Court to take that course.
Is this the only submission from the appellants on the question of delay in writing below?
Can I check that over short adjournment, my lord? Because off the top of my head, I can't.
I think we'll also just need an assurance that, I mean, presumably, although we've heard and you accept that the question of relief in itself wasn't the subject of oral submissions, whether in the discussion of delay, which obviously was the subject of oral submissions, the point that I'd be putting to you was raised.
My lord, yes. And I'll, given that you've raised it, and I haven't necessarily thought about it in quite this way,
Yes, quite.
I'll also do that check.
Yes, that would be helpful.
There's a bit in, I think, the dependent skeleton argument about quashing orders and recovery and discretion. If you look in the core bundle at page 710, which makes the perfectly valid point that relief is a question of discretion.
Yeah. Well, my lord, I think there's no doubt in anyone's mind that if permission had been granted, there was going to be an awful lot to be said at the remedy stage. But our point was we didn't want to get to that stage because it just would prolong the uncertainty. And given the Senior Courts Act allows permission or relief to be refused on grounds for delay, we asked for permission to be refused on grounds for my lord, the next heading is the...
Well, I see the time. If minutes count, you can go on for 2 minutes, but it's probably quite a good place to break, isn't it?
I'm very happy to.
I keep getting to bring with me the timetable. How do you envisage the afternoon going? What's the time that's been allowed between counsel for Mr. Beale and Mr. Perrett to get to their feet again?
I've got half an hour allocated, which is going to be 3:30, and then an hour for Lord Panic.
So effectively, you go on till 3:30, and they get 3/4 of an hour.
That's right.
Okay, if that's what's been agreed. That's fine, but I think you will need to. You won't get much leeway. It'll be Lord Panic, I'm afraid, who may be the loser.
We'll have to see what he has to say about that. I'll do my best to speed up.
Very well. 2 o'clock.
For Brian Cable.